All right, welcome back. So we're still in Chapter 3, which is Interests in Land. Hopefully the stuff for this week is going to turn out to be easier than the stuff for last week, which was particularly hard. But we're still looking at the same stuff, right, which are interests in land, estates in land, right, as we call them. So life estates, fee simples, and so forth. You'll notice, by the way, that I got new markers, so hopefully that will significantly improve my handwriting because they were quite expensive. So, first we saw that you can have conditions on an estate, right, and that's allowed. That was the first level of complexity that we looked at. So we looked at life estates, we looked at fee simples, and then we said the whole thing's actually a lot more complicated than that because you can start attaching conditions to all freehold estates as opposed to leasehold estates again, right? So it doesn't apply to leasehold estates. It applies to freehold estates, which include the life estate and the fee simple and the fee tail, of course, but that we don't worry about because it's no longer legal in Canada. Then we said there's a further level of complexity in that. You can start attaching conditions to a freehold estate, namely a life estate or a fee simple. We looked at the various permutations of that last week. I think I repeated it too many times already, so I won't again, right? But it's very important to properly characterize what it is that you're looking at. So the nature of the estate needs to be categorized very carefully because that will determine certain things as to the contingency, because when you have uncertainty, we'll see there are specific rules as to that. And also because it changes the way in which we assess the validity. So if a condition's invalid on a determinable estate, as we saw, the determinable interest, right, then that interest is invalid because it's a whole. The condition comes with the estate itself, therefore invalidating the condition because it's part of the estate also invalidates the estate. In contrast, if it's a defeasible life estate, then the condition is not part of the estate as a whole. Therefore, if you invalidate the condition, it only invalidates the condition, which means that the person will get an estate without a condition. So they get kind of rewarded in that, right? In a determinable estate, it's the opposite. They get punished, right? They lose the whole thing. If it's defeasible, they get the conditions invalidated, not the estate. They get the estate not subject to the condition. So they get, say, a full life estate, not one that's subject to a condition. So these are the various permutations, right? We said determinable is if the limitation is just phrased as, and again, phrased as means absolutely nothing as to the event itself. Phrased as a certainty, even though the event, again, might be completely uncertain, right? So when she has illegitimate children, when conveys certainty, and that's although, right, the fact that she might have illegitimate children is itself very uncertain. Because of the words that were used, it is a determinable life estate, therefore conditions comes with the estate. If it's phrased not as a certainty, so if she has illegitimate children, then it's a defeasible life estate. Condition is not part of the estate. Condition, if invalid, is invalidated separately, right? And we said that, right, the name of the interest will change depending on whether it's determinable or defeasible. So that was the first level of complexity that we saw. So we said, right, first you have a right of reversion, which is not a condition. It's when a life estate ends, grantor or person who has the right to get the thing back has a right of reversion. If it's a third party, as we said, changes its name, still is the same thing. Then we said there's defeasible determinable estates, both of which are conditions subsequent. And so, right, when or if she has illegitimate children, if and when that event happens, the person loses their estate. That's a condition subsequent. They have something, an estate, subsequently they lose it if the condition's met. So both of these are conditions subsequent. Then we said you can also have a condition precedent, which is the opposite. It says you have to meet the condition, right, and there's only one type there, before you get the estate. So it's going to say get the estate, life estate, fee simple, if she finishes law school. If she finishes law school is a condition precedent, and it is precedent to her getting the interest that she got. So she has to meet the condition to get the estate. And we'll see that's significant again because there's uncertainty, right? She has nothing. So that's uncertainty. Uncertainty as to whether the interest will vest. Again, that's what uncertainty means. It doesn't mean uncertain as to timing. It means uncertain as to happening. So life estate's not uncertain because we know people die, right? So the right of reversion is not uncertain because it's certain as to happening. It's just not certain as to timing. People die, we just don't know when. In contrast, condition precedent, if she'll get the estate if she finishes law school. That is uncertain within the meaning of the law, right? It's uncertain as to timing, but it's also uncertain as to happening. We don't know if she will finish law school or not. We'll see the relevance of that shortly. Now there's a further level of complexity, of course, with conditions, and that is that not all conditions are valid. And that's where we get the relevance of what I just said. The relevance of whether the invalidity of a condition, once pronounced by the court, will invalidate the entire estate. That's where the distinction between determinable and defeasible starts to matter. Because the consequence of invalidating the condition, which you're doing in both cases, right, is going to be different. So, condition has to be page 244. And these are all really permutations of the same thing, right? Okay, so has to be, quote, not an impermissible restraint upon alienation. Why is that? Because people have a right to do whatever they want with their stuff. And you can put conditions, but we don't really like that because you don't own it anymore, right? It's kind of weird if you get something and then for 30 years you can't even do what you want with it, even though the registry says you're the owner, because some dead or alive person decided you couldn't. We like it to be that when, right, it's transferred, it's transferred. You can then do whatever you want with it as the person who has the right of ownership is found in the registry. So we'll permit some restraints, but not too many, because again, the person that's imposing a bunch of conditions is no longer the owner, and oftentimes they are dead. Second, it has to be certain, and that's a pretty stringent standard. It just has to be applicable by the court. So if it's really vague in its phrasing, right? So it's going to say, I want this person not to marry a person, say, of religion. And it's not clear what that means, right? Because it's extremely vague. It has to be vague, and that example might not even cut it, right? It has to be so vague that the court's unable to apply it, basically. That the court just can't tell how it can be applied, and therefore the condition will fail. As we'll see, there is greater tolerance for conditions precedent, and that makes sense, right? Because a condition subsequent is in suspension for a longer period of time. And lastly, it has to not contravene public policy. Again, all the same thing, right? We don't want it to be impermissible because we don't want dead people to control stuff once they're dead, which really is a public policy reason, right? It's a public interest within a private transaction, because that's what a sale is, right? When you transfer property, again, for free, for money, when you're alive, when you're dead, whatever it is, it's private. It's two people, right? It's not the government. Nonetheless, there's a public interest in making sure that dead people don't control people, oftentimes because, as you saw from the readings, they tend to have, right, racist or a bit older views. So, public policy, again, same rationale, broader category allows the court to strike down something that's against public policy. We'll often see that, as we'll see with discrimination. Discrimination is against public policy, right? Which is, again, this broad category of things as a society that we really don't like, and therefore that we allow judges to apply. And that generally is exercised carefully because of how broad it is, right? Because you've got an unelected judge really deciding that something is a common value within society and then striking something down within this broader matrix that we have that people are supposed to be able to do whatever they want, right? And then it gets struck down by a judge. So usually it's used carefully for things that are just completely against society's mores. And there's less and less tolerance of these issues today. So lots of the cases, the earlier cases, you don't read that many of them, that uphold certain discriminatory or conditions that appear to be against or would appear to be against public policy today. Most of these cases probably would have been decided differently today. Okay. So, first case is Blackburn, which you're told is where the Supreme Court adopts an absolutely new and innovative approach in 1903, no less, right? Basically, you've got a father transferring an interest, right, in land to his kids, and that is postponed in time. So they only get it, I think it is 25 years from then. In the meantime, he says, the kid cannot mortgage their interest. Why is that important? Because normally they could. Why is that? Because it is an interest that is present and certain. What is it, right? Because again, present doesn't mean certain as to timing, because if you have a right of reversion on a life estate, the timing that your interest will come into being is uncertain, but it's certain as to happening. So it is a corollary of that. You don't have possession. That's what a life estate is. Life estate is going to say to A for life. Well, A has possession for life, and then you get it back when they die. So you have a present interest because it's certain as to happening, though not certain as to timing. And you have an interest that we call non-possessory, because there's nothing that says that you have to have possession to have an interest, right? If you're a landlord, you have an interest, of course, in the property. You don't have possession. Sometimes they come together. By default, if you have a fee simple, so quote-unquote full ownership, they do, but they don't have to. You can give it away to someone else one way or the other. That's what a life estate is. So, it is a non-possessory interest, and that's still an interest that is both present and certain, because you will get possession later on, right? And that is certain to happen, although uncertain as to when. Same thing there. If the will says the kid gets the land 25 years from now, that is certain, but it's non-possessory. In that, he doesn't have possession for the first 25 years. And so, because the interest is certain and present, it's something we saw last week, he can exercise certain rights. So for instance, if it were a life estate, he can come in and tell the life tenant, who again is not a tenant, right, but that's what the word is, tell the life tenant, hey, stop screwing my house up because then it'll be worthless when I get it back. And in that way, they're not exercising a right to possession that they don't have. What they are exercising is their right to eventual possession. They're saying, when I get eventual possession, which is certain, it's going to be worth nothing because you just started punching the walls. Therefore, they can protect the value of that non-possessory interest, which is an interest of future possession, by coming in and saying, I want you to stop punching the walls. And they can do that because they have an interest. If they didn't, they couldn't. If the interest was when she finishes law school, well, before she finishes law school, she is nothing. So she can't go to court and sue anyone for anything because she doesn't have an interest yet. That's where the distinction becomes relevant. There, if it says he gets possession in 25 years, it's an interest that is present, therefore he can mortgage it. Because it's his. Right? He can mortgage it as long as he doesn't give something he doesn't have. What he has is possession 25 years from now. If he starts renting it out and offering people possession, that's not legal because he doesn't have that. But because he has an interest, and interests are, as we said, all interests are freely alienable, he can mortgage it, just like he can sell it unless there's a condition that says otherwise. And therefore, he can go to the bank and mortgage it. He's allowed to do that. That's a restraint on what he could otherwise do with the property. And that's why the court finds that, right, it's an impermissible restraint. It's too significant, and therefore the court strikes it down. Specifically, what happens is he actually mortgages it, then the bank, he defaults on the mortgage, bank seizes it, and then right later on someone in court says, hey, this whole thing wasn't legit because the mortgage contract was essentially against the deed, was against the transfer document, which had a condition in it. As a side note, normally, as you can imagine, right, you have these conditions have to be public in some way, right? Because of course, if there's a registry that says you've got to know who the owner is, for the same policy reasons, because we don't want people to buy something that's not really the seller's, because we want people to be able to check whether or not you've already mortgaged your property and therefore are not solvent for a further mortgage, right? All these underlying policy considerations. Of course, they also apply to a condition. We also, for the same reason, want these people to know if, in fact, you're not allowed to sell. Same thing, right? It's as if you sold a house that's not yours. If you sell something where there's a condition that says you can't, the sale will be invalid, unless the condition is later invalidated, of course, right? Sale will be invalid, and that's a thing you want the buyer to know. Therefore, you'd want it to be in the registry. There's something we call numerous clauses, which we won't look at yet. Get you excited about that. But basically, the rationale for that is that you have predetermined estates, and we want there to be limited flexibility in creating new ones. So we have a life estate, we have a fee simple. There's nothing in between in law. And we don't want there to be anything in between. So we'll let you attach conditions that slightly limit or define the nature of either of those, life interest or fee simple. But we won't let you put so many conditions, and again, that's just right an underlying reason for these things, that you are changing the nature of the interest too much and therefore creating a new interest that is unknowable in law. Page 248, you've got a bunch of examples. It's always subjective, right? As you can imagine, it means what it says, right? A substantial restraint, well, if it's a long period of time, the longer it is, the more likely it is to be substantial. If you can only sell to one person or 5 people, it's very few people to sell to. It's a big limit, therefore it's less likely to be valid, right? All that being kind of subjective and along a continuum. Okay, then you have the Sifton case, which is a case from the Privy Council. Back in the days, there was something above the Supreme Court called the Privy Council that had the final decision-making power. So if you weren't happy, right, the final decision maker, which is now the Supreme Court of Canada, right, would have been the House of Lords in England. You have to fly there and plead your case. That's what happened there. They end up before the House of Lords, 1938. Again, always note the reference there. The year can be relevant, and certainly to the extent that, as we have seen, first, right, of course, if you're being assigned a case from England, it's because that case eventually was imported into Canada by the process that we saw last week and that we call reception. Nonetheless, right, noting the year, regardless of whether it's a Canadian case or an English case, will be relevant for you to assess the likelihood that these principles still apply today, especially when you're given a bunch of cases in the textbook that are not always assigned in chronological order. So pretty simple case, you've got a condition that she continues to reside in Canada. And that condition eventually, that's the punchline, is struck down. Why? Because it's uncertain. It's hard to assess. If it said she has to be in Canada a majority of the time, it would have been simple, right? Then you would have done the math. If she's there a majority of the time, then she meets the condition, doesn't lose her estate. Again, it's important there, right? Whether it's determinable or defeasible. If it's determinable, condition's part of the estate, she loses the entire estate. If it's defeasible, condition's separate, therefore if you invalidate the condition, she gets the entire estate, not subject to the condition because the condition's invalidated. It's not clear for that reason, and it's also forever, essentially, right? There's no time limitation. If it were for 3 years, the court might have been more willing to speculate as to the meaning of stay in Canada, but now it's indefinite, and on top of that, there's no clear definition. Court of Appeals says we can just make it up, right? It says we'll count the months or something, and then the Privy Council, the final instance decision maker, says that it is too uncertain. And that's uncertainty, right, in the phrasing of the condition. So it's uncertain as to happening, of course, right? But that only matters if it's a defeasible life estate. And, right, it's uncertain because the court cannot apply it. So it's not just uncertain as to whether it will happen or not. It's uncertain as to how the court will interpret that and apply it, as to how the court will apply what is written, and therefore it fails for uncertainty. So all that to say, the ground of uncertainty of a condition has nothing to do with the other kind of uncertainty we talked about. So the certainty of an interest doesn't make it invalid, right? So all my examples, it's got nothing to do with that. So all my examples, right, when she goes to law school, she gets the interest. It's uncertain, it's condition precedent. It's uncertain because it's uncertain as to happening. She might never finish law school. Not the same thing as a condition that is void for uncertainty. That is when the court reads a document and the document's so unclear that it can't be applied, then the condition will fail for uncertainty, right? A condition with an uncertain event doesn't fail. As we'll see, there just are conditions as to what happens when it's dragged down, what happens when it lasts for too long, the uncertainty lasts for too long. That's uncertainty in the drafting, and it's related to the other concerns that we discussed, like public policy. There is, in that case that's mentioned specifically, what we call a presumption in favor of early vesting. So, sometimes it will not be clear whether it's a condition precedent or a condition subsequent. In other words, it won't be clear whether she gets the estate, fee simple or life estate, and then loses it if something happens, if she has illegitimate children. That's condition subsequent, whether it's determinable or defeasible again. Then it can also be condition precedent, which is the opposite. She doesn't get the estate until the condition is met. She'll get the estate if she goes to law school, right? And then she gets it if and when she goes to law school. If she doesn't, she never does. That, right, isn't always clear. If it says she will get the interest, or she gets the interest until, then it's clear which one it is. Sometimes it isn't. It's not clear whether it's a condition precedent or subsequent. So it's not clear whether she gets the estate and then loses it if something happens, or whether she doesn't get the estate until something happens. To the extent that it's not clear, there is a presumption as to early vesting. We favor, in that case, the interpretation of the words as a condition precedent, right? And that's in that case, but in a bunch of other ones as well. But we favor that for a number of reasons, but that's the general rule. So if it's not clear, we favor that. The reason is, first, it gives people an interest. Second, it reduces uncertainty because it postpones it, right? If you have a condition precedent, you're more likely to have to show up to court because the person won't get the interest They want it, therefore they'll have to sue to see whether or not they get the interest. If it's a condition subsequent, they get it and then lose it, and then someone has to make the claim for them to lose it one way or the other. Therefore, right, it's less likely the court will have to apply it. That's why the court generally tries to favor early vesting, which really just means a condition subsequent as opposed to a condition precedent, when the interpretation of the condition is unclear. And that's why the courts, as I said earlier, will also tolerate a greater level of uncertainty for a condition precedent. Okay, then you have cases on discrimination. One of the significant ones is Canada Trust, because it's applied in a bunch of other cases. Essentially, you have, again, look at the stuff at the top, 1990 Ontario Court of Appeal, so relatively recent. You have a guy who creates a trust essentially for racist purposes, to support white and male individuals, right? And over time, it turns out that that isn't quite along society's values, so someone sues. But of course, it's not that easy, right? You can't just call up the trustee and say, hey, this thing there where you just give money to white males seems a bit discriminatory, you should doing that. It doesn't work that way. The trustee, again, trustee being a third party. So trust is a thing that you make up, right? A new entity that you just made up, right? Then you put your stuff in it. It's a trust, and that's administered by a third party that we call a trustee. Gave you that example earlier with irresponsible kid. So you've got $5 million, don't want to give it to a irresponsible kid because they'll go out and get Ferraris. To prevent that, you put the $5 million in a trust. You have it managed by a trustee, responsible person, and a responsible person decides how much of the money the kid gets every year so that he can only buy food but not Ferraris. And the trustee also makes sure that, right, the $5 million is properly invested so that it generates capital efficiently. So that's a trust there, right? Well, the trust says the income will go to white males. Even if you call up the trustee and you say that that's discriminatory, the trustee is bound by the document. The document says he has to give the money to white males. So he can't just say, well, I just decided that that's not legit, therefore I'll stop doing it. I'll start giving it to, right, everyone. Doesn't work that way, so someone has to try to invalidate the trust document itself, has to say that it's against public policy. And interestingly, you run into a bunch of issues, right? First, it's a private document. Same thing as when you sell your house. You don't expect the government to come in and put conditions, right? You don't expect the government to come in and say, hey, real estate's getting expensive in Vancouver, therefore I don't want you to sell your house for $800,000. Doesn't work that way. Same thing there. Guy creates a trust. It's his money, right? He could have given it to his kids. He could have spent it. And he decided not to spend it. He decided to create a trust, right? And ostensibly something that was nice at the time. He decided to create a scholarship for white people. Ostensibly at the time, lots of people thought white people were superior. And then later on you come in and you affect that. And that's both private, right, because it's his money, and he tried to do something good that turned out to be later on, right, racist and discriminatory. So it's complex for the court to step in. It's not discrimination in the traditional sense, right? It's not discrimination per the charter. Then it's easy, right? Then it's the state. State does something, passes a law, regulation, just does something to you. Then the charter applies. It only applies to public action, right? Not private action between individuals. And then you claim pursuant to the charter. You say, I was discriminated against. And that's legit because discrimination isn't. But it's also legit because it's the state. It's not some guy. And in fact, some guy can't discriminate against you pursuant to the charter because the charter just doesn't apply. In actuality, it's more complicated than that, right? We have provincial human rights codes, as we call them, which are going to repeat the same thing as the charter, will extend its application to say businesses of over 50 employees, and then you can claim discrimination, but it's pursuant to a law. It's a regular law called the Human Rights Code, not the Charter. Anyway, Charter would not apply there, right? In fact, that was before the Charter, but if the Charter had been there, it would not have applied because it's a private document, right? You can argue that that's somewhat more public than other cases in that it is in the public interest. It's a scholarship for people that's supposed to do good. You can argue that that's more public than just a will, right? Just someone giving stuff to their kids. Nonetheless, the Charter likely would not apply, right? Almost certainly wouldn't apply. So, you can't really apply anything there. There's also laws at the time, because again, Charter didn't exist. You had some analogous laws, but it was the same problem because their application was the same. That's where public policy comes in. Public policy is this very broad category, which is just, right, stuff that's repugnant to our values as a society. But we just made it up. Some unelected judges made it up. And that's why that category is broad, but it's extremely carefully used because it creates all sorts of concerns with, right, democratic legitimacy, but also freedom of, right, transfer of property. But the court is going to find there that it is first going to repeat what I said on public policy. This is an important takeaway. And then we'll say that it is indeed against public policy in a developed society such as Ontario. That does not limit you from exercising discrimination for a good reason. And that's just intuitive, and in fact, it's what the Charter says. Charter says, right, you have Section 15, which protects against discrimination, and what does it say? Actually, just to correct something I said there, the Charter had been passed when that case was decided, but did not apply. I think I might have misspoken earlier. Does not change what I said. So, under the Charter, you're protected against discrimination under Section 15. Section 15, subsection 15.1 says, you have a right to be free from discrimination. Subsection 15.2 says, but that does not apply if the discrimination is for a good reason, essentially. So 15.1 says you have a right not to be discriminated against, including upon the following grounds. What's that mean, right? It means first that the list is not exhaustive. You can add stuff. And the stuff after that, race, religion, blah, 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 that's enumerated grounds. And you can have additional grounds, which we call analogous grounds. And discrimination, I won't get into the constitutional stuff, but the way it's been defined by courts is, essentially it has to play into a historical disadvantage. That is discrimination. Therefore, you can't allege discrimination if you're a white person, even if you meet the condition. So even if you're being treated differently, which is a requirement, you can't allege discrimination because you're not, it doesn't play into your historical disadvantage. 15.2, subsection 15.2 of the Charter says, right, it says that right does not apply when the government's trying to achieve a good purpose, which is what we call affirmative action in the United States, which was struck down in some varieties by the Supreme Court of the United States because our Constitution, as amended, is very young. Charter was passed in 82. Right, the people had the benefit of experience, wanted to avoid that same thing being done in Canada. So programs that exercise positive discrimination being struck down. So for example, you create a program that says you'll give $10,000 to African Canadians to buy houses. That's discrimination. It draws a distinction in that only African Canadians get the money, right? And it can play into historical disadvantage by, say, excluding some other disadvantaged group. But that's permitted under, not white people for the reason I mentioned. That's permitted under subsection 15.2 because it's what we call an ameliorative program. There, clearly, the government is drawing a distinction, more specifically a discriminatory distinction pursuant to 15.1, for a good reason, right? To alleviate the historical disadvantage of African Canadians, and therefore we allow that. Again, the 15 stuff isn't important if you didn't get it. That's the background for it, right? But essentially we have a policy in Canada that allows for positive discrimination, for the purpose of alleviating historical disadvantage / discrimination. And therefore we also allow that under the common law of property. So the guy's thing wasn't valid because the guy said, I want white people to be superior and only white people will get it. Ostensibly, even if he didn't have the beginning stuff there, right, where he says that white people are superior, it would likely also have been struck down if it only advantaged white people, because white people aren't historically disadvantaged. But that's subjective. However, if he creates a scholarship, again, assuming he doesn't use the racist stuff at the beginning, and that's a scholarship for Muslims, for example, so they can get better access to education in Canada. That's discriminatory in the same sense, but that would be allowed because it's positive discrimination. It's a scholarship, and you don't want people, right, to start creating scholarships and then it's always struck down, because you want people to create scholarships. And you also don't want to prevent people from helping specific groups that they care about, especially when these groups are disadvantaged. So that scholarship for Muslims only would be valid because, right, we first want to allow for some freedom there, and second, and more importantly, because it's ameliorative, because it seeks to alleviate the disadvantage of a group. And that's why you draw a distinction. That's why you give it only to a particular group. You also have the remedy in that case, which is kind of important, which is what we call the Cypre Doctrine. Essentially, the court will not invalidate the document if that happens. So if it's a charity, and the charity says that it's only for a specific group of people, so it's only for white males, that turns out to be something invalid for some reason, right, against public policy. It's struck down, but you don't cancel the entire trust. So if you did, right, you might give the money back to, say, the guy's kids if they still exist. The court preserves the intent of the person who created it, the trust, by rewriting it in a way that is consistent with the intentions but legal. So they will rephrase the charitable purpose as closely as possible to the original but legally. So, for example, if it's for white males, right, it would just be a university scholarship, period. And you'd remove the discrimination. You would stay close to the intention of the person, right? If you just said it's going to be a general charitable trust that can give to anything, that would be further away. So keep it specific, only for university studies. And, right, that also means that you don't invalidate the entire thing. So the trust remains a charitable trust. This doesn't help the exact same people because it's rewritten to be legal. Okay, quite importantly at pages 263 and 4, what I said is mentioned. If it's a private transfer, if it's a deed or a will, so you give money to your kids, it's more likely that discrimination of some sort will be tolerated because it's less public than a charitable purpose. And because people have essentially, right, a full ability to decide who they give their money to. If you only give money to one of your kids, it's not fair. But that doesn't matter because it doesn't have to be fair because it's your money. You can give it to whoever you want. You can also spend it. Therefore, the other kids can't claim that it's unfair because it doesn't have to be fair. It's a free transfer of property done out of generosity. Therefore, it's more likely that discrimination will be tolerated than for, say, a charitable trust, and, right, that discrimination most often will be implicit. So if it's written down, I am disinheriting my kid because he married a white female, that would more likely be struck down than just not letting your kid inherit, because then the discrimination is more likely to be tolerated, and on top of that, it's not apparent on the face of the document. And there are rules as to evidence you can introduce in court, which would be a problem there, right? You can't just show up to court and say, this is proof that the document is the opposite of what it says. It doesn't work that way, right? If it's clear what it says, it's what it says. You don't get to show up and try to change a thing. If it's unclear, then you can bring in evidence. So you'd have evidentiary issues to the extent that you could somehow manage to do that. The court wouldn't welcome that argument because it's a private transfer of property, and on top of that, the discrimination does not appear on the face of the document. And that's the BMO case from 2016 in Ontario. So somewhat recent, which applies Canada Trust, right? Which is the earlier case from, I think, 1990 about the white male thing. And that case is more recent, distinguishes the facts there for the reasons that I mentioned. Okay, the exercises there you'll go over with Emily during the Monday session. If there's still stuff to talk about, we will talk about it on Monday, but I won't go over the exercises kind of systematically. So, further complication, of course, is the rule in Shelleys Case, which is of very little relevance for our purposes, frankly. Nonetheless, we'll talk about it because it's part of the law of property. Interestingly, doesn't apply in most places. So in England, they were smart enough to pass a law that says this thing makes no sense. In Canadian provinces, like I think Alberta, Nova Scotia, they did the same thing. In Ontario, they didn't. So it was unintentionally imported into Canada through reception, and therefore it still applies, again, because the stuff that's been received, there's a date up until the date. Before the date, it applies, right? The stuff that was decided in England before the date, it's important as of the date, therefore applies after that, until it's repealed by statute, because, as we said, the statute always prevails. The judges get to make it up in the first place, but the elected people always get to say that they're not happy with that and change it. What happens there is that you give, we'll put the language here because it's important, to A, comma, so you're essentially breaking it down in a way that's very simple. Life estate, right of reversion. To A for life, remainder to B, and is heirs. We saw that. This is the most simple example. A gets a life estate. B gets a right of reversion, namely a right to get the house back, or whatever it is, when A dies. That's a right of reversion, or a remainder interest, depending on who has it. That is a remainder, we didn't say it that way yet, but a remainder in fee simple, which is confusing, but what it means is that first, it's the rest of the thing. And we said that 20 times. So to A for life, remainder to B and his heirs, O, the grantor, gets nothing, because they transferred part of it to A, namely a life estate, and then they transferred the right of reversion to B, which was everything they had left. So, bundle of rights, they transfer one thing to one person, the rest to the other person, they got nothing left. We said that already. So if you transfer a life estate and a right of reversion, you retain nothing. If you only transfer a life estate, you retain something, namely a right of reversion that you didn't transfer yet, and you can transfer some other stuff, in which case you retain the rest, which is different, but it's the same principle. For that reason, B, we often say, gets a remainder in fee simple, which just means that once A dies, they have everything, because A had a life estate. They died. When they died, they had nothing, because a life estate is for the duration of your life. When you die, it ends. So when A dies, but just when that happens, O, the grantor, has nothing because they transferred it all. A has nothing because they died. B has everything. That's why we call it a remainder in fee simple. It's, I think, confusing. That's why I didn't use it. It's confusing in that it's not a fee simple yet. It just isn't. Once A's alive, it's a right of reversion, and that is not a fee simple. Fee simple would be an absolute interest, and that would be if A didn't have a life estate. So it's only when A dies that they get a fee simple, and that's just a conceptual consequence of what we saw. It's not a rule, it's not the law, it's just a different way to say what we said, and then put a word on it that's extremely confusing because it only describes an interest that they will have later as a consequence of the stuff we learned, but by using a word that's confusing. So for that reason, you don't have to worry about that too much, but you'll sometimes see remainder to be in fee simple, and that is a valid transfer first. And second, it's not a transfer that means that they get anything more. They just got a right of reversion. They just didn't use a word reversion or remainder to be, right? They said to be and is a remainder in fee simple. Still a remainder, still the same thing. So, you transfer to A for life. Remainder to B and his heirs. That's what we said. Or it could be, right, to B, it could be to B, remainder to be in fee simple. Would be the same thing. What if then, instead, you give it to A's heirs? So you say a life estate to A, remainder to A's heirs. That is not a fee simple, of course. It's a distinct interest. If it's to A and his heirs, period, it's a fee simple to A. And the consequence of a fee simple is that it is the whole thing, as we said. So to A and his heirs are the magic words to transfer a life estate. Therefore, right, the heirs get nothing. Because to A and his heirs means nothing, it just means it's a fee simple. Therefore, A gets a fee simple, the heirs get nothing. It's just the magic words, right? So again, if A decides to give it away, the heirs can't sue in court and say, well, we didn't get our hereditary privilege, therefore our rights were prejudiced. Doesn't work that way, they have no right. Heirs is the magic words. What if it's phrased as to A for life, remainder to A's heirs? Then it's not the magic words, it's an actual transfer. So to A for life, A would get it for life. Then remainder to A's heirs. Again, not the magic words, it's a transfer. What is that? It's a right of reversion, you know that, right? It's a right of reversion, therefore, the heirs have a present right to future possession. So, you have to decide now who the heirs are. Because you're giving them a right of reversion, which is a right to get possession at the end of the life estate, and that is a present interest. So, as in A and B, to A for life, remainder to B, well, you have to give it to B now. Well, if you give it to A's heirs, it's the same right. It's a right of reversion, so you give it to the heirs now. You don't wait until A dies, because it's a present interest, and it's a present interest that has to be present, so you give it to them now. So, because of that, first A would get it for life, as is written, and then the heirs would get the right of reversion, the remainder interest, because they're a third party to the grant, right? Again, same thing. And they would get it now, not when A dies. So you'd have to look at whether A has kids. The rule in Shelleys case prevents that. It says when it is phrased that way, then we'll just make it up and say that A gets the whole thing, even though that's clearly not the interest. And that's for historical reasons. Essentially, when you died, you had to have heirs. Your heirs had to pay your feudal lord before they got the property. If you transferred it that way, you could get around that and essentially avoid paying your feudal lord. That's how it came up. It has absolutely no relevance today, but it remains, right, a vintage of common law property because it was, again, imported into Canada but never changed by statute. So, rule in Shelleys Case, as you're mentioned, is a rule of law, not a rule of interpretation. Namely, it just applies because someone made it up. Doesn't matter that it clearly defeats the intention of the person. And it almost always will. Doesn't matter. It's a rule of law. It just applies. So when it's that, A will get a fee simple. Now, so if it says that to A for life, remainder to A's heirs, right? Then instead of A getting a life estate, they get everything. They get a fee simple, which was probably not the intent of the person who granted it. There's a few issues on that. First, it does not matter that there is an intervening interest. So, if it says, and these are important things. So we'll take them we'll take them sequentially though, right? But first, it doesn't matter that we'll take them sequentially. That'll make things less confusing. First, it doesn't matter that there's an intervening interest. So if it says to A for life, then to B for life, then to A's heirs, that's the same thing as what I wrote down, but it's got something in the middle. Namely that after A's life estate, B gets a life estate, and only then do A's heirs get it. If that's the case, there's an intervening estate, the rule still applies, but it is postponed. So A does not get a fee simple yet. They get a life estate for now. They get their life estate. Then, but the heirs get nothing because the rule applies. Then B gets their life estate. Then, once B dies, A gets the rest by application of the rule. That's why the heirs got nothing in the first place. A gets the fee simple. The distinction is they don't get it now. Why? Because if they did, it would cancel B's estate. This is to A for life, then to B for life, then to A's heirs. If you said the rule applies, A gets a fee simple, that would make B's life estate disappear because it would be inconsistent, right? If A gets a fee simple, the whole thing, and they get it now, well, then B doesn't have a life estate. So for that reason, it will be postponed. A will get a life estate and a fee simple in suspension. B will get a life estate when A dies. And then at the end, right, it will go to A in fee simple, or whoever inherited from A, because again the interest is because A is dead. That's why their life estate ended. So the rule still applies if there's something in the middle, but its application is suspended. The other important thing is it has to be as is for the rule to apply, except if there's an intervening event, which is why I said we take them sequentially. So if there's something in the middle, still applies. If it's a variation of the phrase that's not that, another variation, then it does not apply. So if it's to A, then to John, Rose, and David, who are the three living kids of A. Well, clearly it looks a lot like that. You're giving it to A, remainder to his heirs. It's just instead of saying heirs, you name them. Rule does not apply because it has to be the exact same thing unless there's an intervening event. So if it's remainder to David, Rose, and John, it doesn't apply. So it would devolve as if you didn't have the rule. So A gets the life estate, the kids get the remainder interest. When A dies, they get the property. If it's to A's heirs of his body, so a specific kind of heirs that doesn't go too far if you don't have a will, right? In the government looking for people to inherit from you, same thing, rule doesn't apply. If it's limited in some other way, if it says, right, issue lineal descendants, whatever the language is, if it limits the class, heirs is absolute. If it limits the class to a specific kind of heirs or a specific group of people, then the rule will not apply. And you have that essentially in the case, which has got to be the most confusing case you'll have this entire semester, right? The Reinhardt case. But essentially, the person who's trying to have their will executed does that. They give someone a life estate, but it's limited. It's determinable. So it's not this. It's not day for life. It's day for life if. So again, you're varying the traditional phrasing, right? And it's not remainder to everyone. Therefore, the rule does not apply. And we'll try to take a break there.